Yes, I salute you all. Thanks for listening and thanks for watching. So basically, today we are under constitutional law, and the topic of emphasis, the topic that we are going to look at, is the topic of constitutional interpretation. Constitutional interpretation, basically, they can be canons of constitutional interpretation. They can be principles for constitutional interpretation, as we are going to see, basically. Let me hope, yeah, microphone is on. So, thanks for listening. Watch, like, and comment. So basically, the canons of constitutional interpretation, these are some of the principles that the judges use while interpreting the constitution. What do I mean is that the judges, based on them, while they are trying to investigate and interpret and make a verdict concerning to the decision brought before them. These are the things they consider. So there can be called canons or principles of constitutional interpretation. First of all, we are going to look at it that the constitution must be, one of it, the constitution must be interpreted as a whole. What do I mean by something to be interpreted as a whole? Basically, this means that that thing or something that is interpreted as a whole, that if you're to read the whole, let me give an example. Article 128 provides for fair hearing. For you to understand what they mean by fair hearing, you must read even the clauses. So that's what they are meaning. It must be interpreted as a whole, not bits. So long as you have got to know that Article 28 provides for a fair hearing, you say that everything is a fair hearing. No, it must be interpreted as a whole. You get? Don't interpret it by bits, but interpret it in its whole. Read clause 1, clause 2, clause 3, clause 4, so that you can understand what the whole article is on. That is one of the first principles. And it was portrayed in the case of South Dakota versus North Carolina. South Dakota versus North Carolina. Under this case, the judge held that no single provision, basically lamented, saying that no single provision of the Constitution is to be segregated from the others to be considered alone. So no single provision shall be segregated from others to be interpreted. Actually bearing upon that the particular subject are to be brought into view. Basically, note that in mind, or bear that in what? In mind, basically. That is the case of South Dakota versus North Carolina. Then another element that we want to see, that the words must be given their natural meaning or ordinary meaning where they are not ambiguous. Basically, when you go to the rules of statutory interpretation, that is the literal rule, basically under legal methods. So basically, where the words are not ambiguous, they must be given their ordinary or natural meaning. Basically, note that in mind. There is a case of R versus Elman. Elman is L, capital L-E, then hyphen, then man is M-A-N-N. Under that case, that's where the court held that where the words are not, they are not ambiguous. They must be given their literal and ordinary meaning. You get? Then you also have another element whereby the meaning and effective rule of interpretation should be used. You get? What do they mean here is that the meaning and effective rule of interpretation should be used. Basically, I'll also refer you that, we have the rules of statutory interpretation. We have the purposive, omissive, golden, and the literal. So, any of those meaning or the rules of interpretation, you get, where they see that this is meaningful and it is effective rule, it must be used. You get, basically here they are meaning that the meaning and the effective rule of interpretation should be adhered to. You get, let me hope you are getting my point, is that judges, while interpreting, they must use that effective and meaningful rule of interpretation. This was in the case of Unity Do versus Anthony General of Botswana. Unity Do versus Anthony General of Botswana, there is a judge who was, is it Amisha, such a name like that, who said that the makers of the Constitution do not intend that it is to be amended as often as the other legislations. Indeed, it is unusual, you get it? It is unusual for the provisions of the Constitution, basically, for the provisions of the Constitution to be amendable by special procedures, imposing more difficult terms and heavier majorities. You get, for you to amend something, it needs majorities, basically. So what is implying that where there is meaningful and effective means of interpretation must be adhered to. You get, because constitution is not vertebly, it is not sanctioned to amendments, previous amendments. Remember the fight of Toji Kwatako. It was a ruckus. So it is not easy. Then we have the sui generis rule as also a principle or a canon of constitutional interpretation. Sui generis in the layman's understanding, it means something of its own kind. Something of its, if someone tells you that you are sui generis, it means you are of your own kind. You are not the same as, actually, you don't have any copyright, you don't have anything that resembles you. You are of your own kind. That's what they mean by sui generis. Sui generis what? Sui generis rule. So basically, the sui generis rule, it was portrayed in the case of Tomushabe versus Anthony Gino. Joseph Tomushabe versus Anthony Gino, where the court held that the law that governs bail in Uganda, it is in Article 23, clause 23, clause C, 23 C, 23, clause C, paragraph A, B, and C. Any other law which contravenes with the law of bail that is in the Constitution is null and void, or it is inconsistent. Basically, they wanted to show that the Constitution is one that provides the law of bail. There's no any other law that provides the right to bail or the law on bail application. Basically, that's the meaning, or that's what they were trying to bring on board, basically. That's what they were trying to bring on board, to highlight that the law of bail is only in the 1995 Constitution, giving that element of a sui generis rule. And also we have another principle of constitutional interpretation, which portrays that the Constitution must be interpreted as a living document. What do they mean by something to be interpreted as a living document? This one, it means that the Constitution that is here today, it must be used by our children and our grandchildren. Basically, that's the meaning. We must use it, the children and the grandchildren. So it must be interpreted whereby we base even the future generations to come. For example, the Constitution that we are using currently is of 1995. But me, I personally talking, by 1995, I wasn't yet born. But the interpreters have that in mind, that there's a generation that is coming that must also abide by this Constitution. Whatever verdict you use under interpretation, you must be considerate to the coming generation. That is the case of Tinyefunza, General David Tinyefunza versus Anthony Gino, where the court held that while the language of the Constitution does not damage the changing circumstances of progressive, you get, which was designed to give the rise of a new or important meaning that would be used by the future generations. You get. So basically, the language used must also be adhered to the changing circumstances. That is the world that we are in. It is changing. It is versatile. Then we also have another principle, that the preamble and the national objectives and directives of statement of the state they are also necessary to be taken in account to supply the intention of the framers. Basically, the point that you are looking at, or the point that you are trying to argue, is that the objectives, the preamble, and the directives, they are all, mostly in our Constitution, they are in those framed before Article 1. The preamble and objectives, they are the first papers of our Constitution. So they must also be adhered to in the supply of the intention of the framers. Still, we have the case, they say, the case of Anthony Gino versus Tinyefunza. That case portrays that, whereby they held that it is important to know and appreciate the historical and contextual background. The historical contextual background to the Uganda's constitution, and we can never fail. We get it through reading the preamble and the objectives or the directives that are inside the what the constitution. And knowing them, you can know the bottom line on how you can interpret the articles within. You get. Then another principle that we have that the fundamental rights and freedoms guaranteed. Note that the fundamental rights and principles, freedoms guaranteed under the Constitution must be interpreted having a general regard to evolving standard of human dignity. Where basically here they are trying to show that even if court is to interpret the Constitution, it must be considerate to the fundamental human rights and freedoms guaranteed or invested in that particular Constitution. That is the case of Andrew Mwenda and Charles Onyango Bo versus Anthony General, where these people were convicted for the offense of sedition for the false publication that they made. You get, but ever court held that this section, it was repealed, section 50, I think 50 of the penal code. It was repealed, saying that it was violating Article 29, right to freedom of expression. You get, so note that in mind. Then another principle that we have is that the international human rights and conventions and treaties must also be used in what? In interpretation. What do I mean here? That the international treaties and conventions must also be adhered to in interpretation. Basically here, what I'm trying to mean is that in consideration, maybe the legislators, maybe the interpreters, those are the judges, must also bear in mind that internationally we are under agreements and conventions. That's why in the case of Unity Do versus Anthony General of Botswana, the court remarked that although it is a common view, note that although it is a common view that conventions do not confer rights on individual within the state until the parliament has legislated and incorporated them into local laws. You get. Nevertheless, this convention may be referred to as an aid of construction of the Constitution, and it would be wrong for the courts to interpret the legislation in contradiction of the international or conventional or treaties obligations, international obligations, basically. This is the element that they are trying to portray, or the element that they are trying to bring out. You get. So basically note that in mind. And we have another element, another principle of constitutional interpretation, whereby they say that it is a rule of practice where the rule of practice is rigid, applied. Another principle is that where the rule of practice is rigidly applied, and it will defeat the process of giving effect to the guaranteed rights, you get, to the guaranteed rights, they must be reasonably relaxed. You get, they must be reasonably relaxed. What do I mean here is that where the rules of practice, they are rigid, and when they apply them, they may defeat the process of giving effect to the guaranteed rights, the Constitution. They can be reasonably relaxed. For example, I relate to Article 126, 2, Clause 2, Paragraph E. This article provides that the courts shall administer substantive justice without undue regard to technicalities. What do I mean? Here, however much in front there, you realize this principle, that is any technicality that comes astray doesn't prohibit from courts to administer justice. For example, let me give an example. When you file in maybe you make a summon letter to summon someone in court, but however there is something like a wrong date, maybe you misquoted the date, what and what. Here, you cannot say that I won't come to court because the sermon letter was held a wrong date. So court may say, you know what? This is something that cannot prohibit court from administering justice. Let's correct it and move forward. You get? So they relax it so that they can move forward and administer justice. Also, in the case of Funza versus Anthony Geno, still it was adding in some eloquent in this principle, whereby Justice Mayindo said, for him, he said that the court said that the case before us relates to the fundamental rights. That case of Funza, these are locus class case, mostly in human rights. They say that the case before us relates to the fundamental rights and freedoms of individuals which are enshrined and protected by the 1995 Constitution. It would be highly improper to deny him a hearing on a technical or procedural grounds. I would even go further and say that even where the respondent objects to the petition, as in this case, the matter should proceed on trial. You get? On the merits, unless it doesn't disclose a cause at all. You get? Hope we are okay with that. We are very, very okay. So he said that a mere technicality in procedure doesn't prohibit us from moving forward. It is denying someone his guaranteed what? Guaranteed rights. So basically note that in mind. Then we also have the harmonization principle. Harmonization principle, which is the harmonization of conflict principle, whereby when two things are, it may be two laws are conflicting, they look at the one that can remedify, is the one that will be advanced. You get? So I'll use the good example of the case of Mitikila versus Anthony Jane of Tanzania, whereby there was a law that was guaranteeing people to contest, to be voted. However, there was also another law that was saying that you cannot contest once you are not in a well-known political party. So the other one was guaranteeing, this one was taking it away. So they brought in the harmonization of conflict principle, whereby they advance the remedy, which is that you have the right to engage in politics. You have the right to be voted for. Unlike the other one that was putting a caveat at it, you get. So that was the harmonization principle. Basically, those are the canons or principles of constitutional interpretation. Other than that, thank you for listening and thank you for watching. Stay blessed. Thank you.